All right, let's now welcome Accountability Now Director Advocate Paul Hoffman. He joins us now via video link to weigh in on this judgment. A very good afternoon to you, Advocate. So as we get your reaction to the ConCourt's ruling, let's also get your view about the section of contention here, Section 61A of the Citizenship Act of 1995, and perhaps help us unpack, the legal reasoning the Apex Court has sought to scrap the Act, thereby upholding the SCA's ruling.
Yes, thank you for the opportunity and good afternoon to your viewers. The starting point with this entire exercise, as is the case in any matter in which the constitutionality of a piece of legislation is challenged, is to see whether the law in question, Section 6, as you've rightly mentioned, is consistent with the Constitution. Section 2 of the Constitution itself says that any law or conduct that is inconsistent with the Constitution is invalid. So let's look at what the Constitution says about citizenship. In the Bill of Rights, there is a provision that says that no citizen may be deprived of citizenship, and that is backed up by one of the founding provisions in Chapter 1 of the Constitution that says that there is a common South African citizenship. Remember, South Africa had, back in 1994, a whole lot of supposedly independent homelands with citizenship in those homelands. So when the new South Africa came about, we decided that there would be a common citizenship, and the same section, Section 3(2), says all citizens are equally entitled to the rights, privileges, and benefits of citizenship. So what the court had to decide, where the Bill of Rights says that you cannot be deprived of your citizenship, and the founding provision is to similar effect, is whether this Section 6, which was brought onto the statute book as long ago as 1995, is in fact in line with the Constitution. And like the Supreme Court of Appeal before it, the Constitutional Court confirmed, because today's judgment is in a confirmation hearing, it confirmed that the striking down of Section 6 by the Supreme Court of Appeal was a valid exercise of its power, and that the deprivation of citizenship of anybody who applies for a second passport or for citizenship of another country, in other words, is invalid and has been since day one. There are provisions in the Constitution that say that you can limit a right in the Constitution if it is reasonable and justifiable in an open and democratic society.
Yeah.
But that didn't happen in this case, and the law is now quite clear and confirms the position.
All right, Advocate, thank you so much for your patience. So you've essentially just reacted to this particular ConCourt ruling and spoke a little bit about the contentious section in that act. What does this mean then for the respondents in this case, the Minister of Home Affairs? I mean, what legal checks, if any, exist to review or appeal? But similarly, and perhaps most important, can those citizens who in fact may have lost their citizenship through the Section 6(1) of the Citizenship Act of 1995 also now take legal route where the Minister of Home Affairs would have to review or perhaps in certain cases reverse that decision? What is likely to happen?
Yes, the effect of the judgment handed down this afternoon by the Constitutional Court is that automatically anybody who was deprived of their citizenship by the workings of Section 6 of the Citizenship Act is reinstated as a citizen of South Africa, even if that person is also the citizen of another country. So nothing needs to be done. Those who have been stripped of citizenship for acquiring a second citizenship without first clearing it with the minister are in the clear. They were entitled to do what they did. The law that said that they couldn't do it does not serve any legitimate purpose of government, and it is a law that does not pass constitutional muster because citizenship cannot be limited. The argument that we got to just before we went off to the funeral, to the memorial service, was that would it be possible to limit the right to citizenship? And the answer on the facts of this case is that nothing was put up by the government to suggest that it was reasonable or justifiable in an open and democratic society to be able to strip people of their citizenship simply because they acquired a second citizenship. I think that is a big win for the people who thought that they were South Africans and discovered by operation of the law struck down that they're not.
I want to just talk about, the ministerial discretion and just the ambiguity around this matter. I mean, could the lack of clarity around retention of citizenship, the process thereof, be grounds for maybe any future legal challenges or legislative reform?
No, well, I think that the argument that was put up, and I haven't seen the part or any part of the judgment that relates to this argument, is that it is beyond the power of a minister in the executive branch of government to deprive people of their citizenship in the way that it was done while Section 6.1 was on the statute book. But in the final analysis, the situation on the ground now is that the provisions of the statute have been struck down as unconstitutional with immediate effect. There's no suspension period because nobody asked for a suspension period, including the minister. And the law is now settled that you can, without the permission of the minister or anybody else, enjoy citizenship of South Africa while also enjoying citizenship of another country.
And what might this, as we wrap our conversation, Advocate, what might this process mean going forward? And I might be going outside of the realm of what you can comment on, but just in terms of, a Parliament, could it come in there and amend Section 6 perhaps? What are we likely to look at in terms of just reforms around particularly the discretionary parts?
Yeah, we're back with Section 2 of the Constitution where our conversation started this afternoon, which is that any law that is inconsistent with the Constitution is invalid. So if Parliament wants to have another bite at this, they have to see if they can find a way around the reasoning in the judgments of the Supreme Court of Appeal, as confirmed today by the Constitutional Court in the confirmation hearing, striking down the validity of Section 6. And I can't see that happening. I don't think that any good purpose can be served by it. And, if you want to make a law, you have to make a law that serves a legitimate purpose of government. And the reasoning in the Supreme Court of Appeal and indeed in the Constitutional Court is that no good purpose is served by depriving South Africans of their citizenship merely because they choose to take citizenship of another country as well.
Advocate Hoffman, thank you so much for your time and, of course, just your analysis. Accountability Now Director Advocate Paul Hoffman just giving us that comment there. A win for the experts, of course, having to keep the citizenship following that Constitutional Court ruling to scrap Section 6.1 of the South African Citizenship Act of 1995.